After 2 weeks. Any day after 2 weeks.
Give a date. Weeks.
25th August.
Page number 41 and 42, Lordship.
Which law is followed for here for the purpose of demarcation?
That is the Mizoram Land Revenue Act 2013, Lordship.
Just give that.
And today, Lordship, no one represents today. The respondent number 5 is absent. So we may fix another date like tomorrow.
No, if somebody who is not present, we are not adjourning.
Your Worship, we represent respondent number 5, that is DC Scholarship. Okay, sorry.
No, this is state law. It will not be in this book.
Section 89 and 90, Lordship.
No, this is Acquisition Act. Not that. He is saying Mizoram Land
Revenue Act.
Land Revenue Act.
2013. Section 89 and 90, Lordship.
Your Lordship, if I may, if Your Lordship will take up the matter today or not, if Your Lordship is taking up the matter, I have some citations to give. If Your Lordship is taking up the matter today, then I have some citations to give, Your Lordship. Or if you're going to fix another date.
Please give it. This book does not have a index. What is the provision for demarcation and verification?
Lordship, that particular provision, actually the main reason which we have to come up before this report is that first there was demarcation as done by the district level, and thereafter an appeal was referred to the director, and again an appeal was referred to the secretary of the Revenue Department, Lordship. And then the main issue which we are proposed is Section 89, interpretation of Section 89 and 90, Lordship. Section 89 and 90. Section 89 talks about the appellate authority.
You are aggrieved by the demarcation.
No, I'm not agree with the demarcation, Lordship.
Your challenge is Annexure 11. 11 is that detailed to conduct a spot verification
Lordship, that's
and
for-
demarcation.
Actually, that spot verification itself is not challenge, but the manner in which it is passed is challenging, Lordship. Section 89 and 90, Lordship.
Your Lordship, in the last court date, this coordinated bench of this honorable court has made an inquiry regarding whether this writ petition is maintainable or not. Your Lordship, the imputed order is only for spot verification. There is no speaking order as such, and they have straight away come to the writ court, Your Lordship. While there is an alternative remedy under the Revenue Act, Your Lordship.
So appeal is provided for. You see the prayer is to show causes to why proceeding arises second appeal, later dated so and so, filed by respondent number 7, along with subsequent proceeding and impugn orders of 10 and 11, issued by respondent number 3 should not be set aside. So where is that second appellate order?
Lordship, that particular order itself is not given, but section page number 41, Lordship.
Page?
Kindly come to page number 41. Page number 41.
No, doesn't help you. If the order based on which these are being carried out If that is not before us, we won't entertain the writ petition.
And Your Lordship, may I kindly take you at page number 39 again, Lordship.
39.
Page number 39. This is,
This is your representation. We don't have the second appellate order.
Lordship, the Secretary is now acting like a second appeal. So that is the reason why we are challenging here, Lordship. So we must find out as to whether this is found to be the second appeal, or if not, by what authority this particular order is issued, Lordship. That is, we have projected here, Lordship.
So where is that complaint which you say is second appeal?
Lordship,
is-
page number 39. Page number 39. This is the retyped copy. And translation.
And where is the original order and the appellate order?
The first appellate, Lordship.
Yes, original order and the appellate order.
Lordship, page number 30,
45,
35, Lordship.
35.
35. And the translation is page number 36. I'm reading, Lordship. Page number 36. May I read, Lordship?
We have read it. And where is the original order?
Lordship, this is the order. The only order.
Page.
Page 35. Translation is page number 36.
That is the appellate order.
Yes, Lordship.
What is the original order? Where is the first,
This is the first appellate order, Lordship.
where is the original order?
There is no original copy, Lordship. This is what we get from the authority, Lordship.
Original means original court's order. The first court's order.
That is page number 35, Lordship.
That is the appellate order.
Lordship, yes.
Where is the primary court's order?
Lordship, page number 27.
27.
Let me explain it briefly, Lordship.
Yes.
Page number 25 is the original complaint, Lordship. Page number 25, and translation is at page number 26. I'm reading, Lordship.
We read it.
To the settlement officer, Kolasip District, Kolasip. Application for revoking a past overlapping my landed property at Serkand Village area. Sir, I have been developing and maintaining my landed property at Serkand Village area since the year 2000 till today. I have also been selling battle nut from arising out of my land for 13 years. During those 23 years that I maintained, no person has claimed ownership over my said land. However, recently, Sri David L. Thangliana had claimed ownership over the said land. However, recently, Sri David had changed his boundary of his land on his own accord, which overlapped my landed property. It is therefore, I kindly request you to cancel the newly issued pass with regard to the change of boundary of the east and west side in favor of Sri David L. Thangliana so as to prevent him from encroaching my land. That is the original complaint, Lordship. And pursuant to this, Your Lordship, page number 27, I'm reading again, Lordship. Order, page number 27. Whereas an application date 31st July 2023 was received from O. David L. Thangliana, son of Lal Chungdunga, with a request to make alteration in the boundary description of his periodic pata number 19 of 1999, located at Kongpui Chimlam, Sairang Road, stating the descriptions with regard to the eastern and western sides needed to be interchanged as they do not tally with actual occupation on grounds. Now, therefore, the undersigned, believing the so-called error to be an inadvertent mistake on the part of the department, and in good faith have made necessary corrections. But whereas objections were received in the form of application from the village council president of Serkan, namely Puvanlal Soma and Pulal Chuam Loya Silo of Zotlang, denying the factors claimed by Pudavid Laltang Liana as devoid of substance and merit. Documentary evidences also being adduced by Pulal Chuam Loya Silo in support of his claim. And whereas verification was conducted on 5th September 2023 by Surveyor of Revenue Department, wherein it was discovered that the area as claimed by Pudavid Laltang Liana is within the area of Serkan Village Council, which may be produced as Pudavid Laltang Liana here. This is in Mizo vernacular. And the next page, the next para. And whereas the claim of Pudavid Laltang Liana, if admitted ipso facto, resulted in overlapping with the periodic pata of Pulalchuam Loya Silo, which again is reproduced from report so and so in the next para. And whereas connected documents of Pudavid Laltang Liana's P-Pata could no longer be traced out, but whereas perusal of his P-Pata reveals a copy of the same, having been given to President Village Council Kontu and not Serkan. The next page. And whereas the location of the land is as claimed by Pudavid Laltang Liana being situated in Serkan Village Council area as evident from Surveyor's report. And whereas Serkan Village Council having never been a part of Kontui Village Council, as again evident from
just a moment. This writ petition is filed by Lalthwamlia Silo, correct?
Lordship.
He made an application for the overlapping of the landed property.
Lordship.
On the basis of this,
And
page 27 order was passed.
Lordship, Lordship. And prior to that, the Lordship, page number 21. Page number 21. Prior to that, the private respondent first made a complaint for the settlement officer. And page number 21 is the original complaint. And page number 22 is the English translation. And pursuant to this, Your Lordship, correction was made. And thereafter, a fresh complaint was made to the settlement officer, which I just have read out. The Lalthwam Loya Silo made a complaint. And basing on that verification, a settlement order was passed. That is page number 27, Lordship.
Just a moment, let me understand.
Lordship.
The land belonged to
Lalthwam Loya Silo.
The land belonged to the petitioner.
Petitioner, Lordship.
Pursuant to the earlier referred letter, the corrections were done.
Lordship.
Then, on your complaint, this order at page 27 was passed.
Exactly, Lordship.
After this page 27 order, appeal was preferred and the appeal maintained
Page number 29 is
page.
59, Lordship. To the director.
No, page 36 is the order. Page 36 is the order which was maintained. Now what has happened?
Lordship.
After page 36, what has happened?
After 36, 37 comes up, Your Lordship, to the Secretary, Government of Mizoram and Defense Settlement Department. Page number 37.
Okay, just a moment. No tribal is constituted.
Sorry, Your Lordship.
Is there any land tribunal in Mizoram? No. Page, section 90 says second appeal. Appeal
Lordship, tribunal is not yet constituted, Lordship.
not yet constituted. Okay. Now, what is the ground on yours saying that the original order which was passed is a land which falls within the
Lordship,
concerned revenue village, that is within Kanpuri village? Where is
Item number 8.
Please, Your Lordship.
Yes.
My Lord, in this case, the respondent number 6 and 7, they were recently pleaded, and I have taken steps upon the respondent 6 and 7 on 15th of July. We may wait for service report in respect of respondent 6 and 7.
Respondent number 7.
6 and 7.
6 and 7.
Yes, Your Lordship.
Postal receipts regarding so-and-so has been received and placed, or AD cards have not been received. Okay. The learned counsel for the petitioner and the learned government advocate are present. Next para. In this, the acknowledgement card in respect of respondent number 6 and 7 has not been received. Next para. Accordingly, the learned counsel for the petitioner is permitted to collect the postal receipt number from the registry and to submit postal track report prior to the next date of listing. Next para. List on 21st,
27th August.
27th August. Okay.
Deeply obliged.
Item number 9.
In this case, my Lord, I have already filed my rejoinder affidavit. Pleadings are not complete. Can be taken up, listed for hearing.
You file your rejoinder.
I have filed. I have filed on 24th July.
This past service is withheld under which notification?
Notification 19/7/2013.
Page
Page number 68.
68.
And there's a corrigendum in page number 72. Corrigendum dated 2nd July 2014.
You see, there are two things operating against you. Number one, when you are appointed, you are a contractual worker. A contractual worker will not be a government servant. That's one. Second is that this notification of 2013, when you were appointed on a condition, you did not accept that under protest.
But my lord, the notification as well as the corrigendum itself provided that
Now, please tell me, if the worker is not a government servant, can his
initially, my lord, he was appointed in the capacity of contract basis under CSS. Thereafter, his service was absorbed under the state government on contract basis. Thereafter, my lord, by perusal of this notification 2013 in the corrigendum, those services rendered prior to regularization on the capacity of either ad hoc, deficit, or CSS can be taken into account for the purpose of upgradation. Even to those other similarly situated employees, these benefits have been granted by the state respondents. And it is no longer res integra that those services rendered under ad hoc or CSS prior to their regular appointment can be taken into account for granting these benefits.
But yes, so far as government advocate is concerned, there is already a judgment of this court which has been annexed here at page 73. Why the petitioner would not be entitled to the benefit of this judgment? Because in paragraph 10 of this order, at page 95, there is a reference to Mizoram government employees counting of past service rules 2020. And considering this court had passed the order. Please come to your affidavit in opposition, para 13 for the state.
Yes.
You say that the petitioner is not similarly situated. On what account? And you have not, in paragraph 14, you are referring to a break, but we find nothing to show how that break has occurred. Break in service. How did it occur? You have not, it's not clear from the documents. You see, the break comes from page 32, which is 3.1. You'll have to spell out what is against the petitioner, how you have constituted the break in service. And why a half-hearted opposition? Without saying anything, you have filed an affidavit. Please show us your appointment order.
Yes, Your Lordship. My writ petition, page number 30, 30.
30.
This is my initial appointment.
No, not initial. Initial was a vocational teacher on contract, not that. Your substantive appointment.
Page number 50, 50. Wherein I was placed at serial number 53.
Then you don't get the benefit.
I was not given the benefits.
You won't get the benefit. Come to page 43. This is the advertisement, person to which you applied. Is it?
Yes, Your Lordship.
Then this is a fresh advertisement. You applied and you got appointment as a fresh candidate.
That is
It's not a
correct,
case of your regularization of service.
That is correct, my lord. This appointment order is a fresh recruitment, my lord. But the notification under which I am claiming the benefits is providing that if the employee had rendered past service under the capacity of either ad hoc or CSS, followed by appointment on regular basis, my lord, we are entitled. This is what has been settled by this court and has already been complied by the state respondents.
Which paragraph?
As for the counting of past service rules 2020, my lord, it provided.
Which paragraph of that judgment? Because what we have read in page 89, that order, it relates to regularization. If this also covers regular appointment, then we have misread this judgment. Please find out which paragraph it says.
My lord, in the case, the writ petition number 33 of 2018, page number 73, my lord. In this case, the petitioners in the petition number 33, they were also denied counting of their past CSS services. Page number 78, my lord, para 11. I'll read from para 10. Page number 77, I'll read from para 10.
No. It doesn't apply. The reason is, as per this judgment, the teachers were under the Sarva Shiksha Abhiyan. Then the government.
That is CSS.
You don't know. Please tell me if I am wrong. Then, pursuant to the judgment of this court, the government formulated a scheme for the purpose of their absorption. And accordingly, this was a regularization scheme which is there in paragraph 7 of the order. After that, the state, by a notification dated 19/7/2013, allowed to count their past services because this was a case of regularization. It was not a case of appointment under a fresh advertisement.
My lord, in this case, the petitioners in WPC number 33, my lord, they were claiming the benefits under this 2013 notification for the portion
This
of,
is-
for the
this-
portion of CSS service.
This page 73 is a case of regularization. It's not a case of fresh appointment.
No, my lord. The similarity is, my lord, these the WPC number 33 petitioners, initially they were appointed under CSS, and then it was followed by state contract capacity, which was followed by regularization into the state government under the scheme.
Fresh advertisement is not regularization.
That I understand, my lord, I got a point. The petitioners in WPC 33 were claiming those persons rendered under CSS. There is no nexus of employment under CSS and state government. Likewise, my lord, in WPC number, page number 86, if I may take a lordship to page number 86.
Please show us anything from this order at page 73 in WPC 33 that they were appointed by virtue of a fresh advertisement and selection process.
Yes, your lordship. Para 6, my lord, page 75.
Para 6 we have already referred earlier to you. This, you see, para 6 is with it relates to appointment contract basis. They were engaged as contract middle school teachers. After that, para 7, rule under 309, that is that notification of
My lord,
2013.
the service which they have regularized to these petitioners were from the state contract, from state
You
contract.
see,
to
nowhere
regular
under the
There is no
central
issue.
scheme of Sarva Shiksha Abhiyan, the appointment is done by the central government. The state government is authorized to recruit and then give it. So therefore, there will be internal arrangement between the Sarva Shiksha mission and the state government for the purposes of disbursement of salary and other emoluments.
But under the scheme, regularization scheme provided by the state, CSS employees cannot be regularized.
Please show us only that one, what you are arguing. You are saying that regularization. Show us that this advertisement was for regularization. Page 43 advertisement was for regularization. It's a fresh appointment. You are not regularized.
Para 9, my lord, all the same judgment.
Of that 33.
70, yes, your lordship. This is number 77. Para 10 onwards.
Just a moment.
From para 10, page number 77.
Para
Para 10, page number
10.
77.
Yes, please read.
In the case of government school teachers, the state government in the school education department by notification 2013, in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India, prescribed the criteria for pay up gradation in the senior and selection grade. A regular confirmed government teacher or headmaster with 8 years of service in the relevant entry grade in the teaching profession would be eligible to enjoy the senior grade, and for the purpose of counting of 8 years service in the entry grade, the service rendered in the ad hoc service continued by regularization into government service without any break would be counted as qualified service. In respect of selection grade, regular school teacher with 16 years of service in the relevant entry grade in the teaching profession will be eligible to enjoy the selection grade. The period of 16 years in the entry grade shall also cover the service rendered in ad hoc deficit service continued by regularization into government service without any break. Pursuant to this notification, the state government in the school education department.
So regularization of service. You see, everywhere you read here, you will find regularization of service.
I got a point. I'll come to the clarification.
Show me only one word where it is a fresh appointment.
the portion of CSS service and the portion
You see,
of,
you'll have to understand that when I'm asking a pinpointed question referring to a paragraph, it's not that you have not understood what you are arguing about. Para 11 says regarding your placement to the senior grade, we should mean that you are already these petitioners were already brought into the grade, and therefore they were upgraded.
by giving them, by counting their past CSS portion of service.
That is covered by the notification, which is made under Article 309.
Yes, Your Lordship.
But when you are a contract employee, previous to your advertisement and the appointment, you are a contractual appointment. Unless the government makes a plan to treat your past services,
My
you
Lord,
would be a fresh appointment. You would
the
be
2014 Prohibitions provided the CSS service, CSS service.
Your employment under the Service Saksha Abhijan cannot be a state service.
That is under.
Shows that agreement where it is a state service. Show your agreement where you have been under the SSA but you are treated as a government servant.
I was subsequently absorbed into state government.
Can't help it. Where is that observation order?
Page number 34, Your Lordship.
34
Yes, Your Lordship.
of the writ petition.
Of the writ petition. My initial appointment was under the CSS, which is in page number 30. Thereafter, under page number 34, my services on contract basis was absorbed under the state plan.
This is extension of the vocational teachers.
Yes, Your Lordship.
So extension of the contract, can it be said to be can you be said to be a government servant? You see, you can still make an election by the government. You make a representation that I will be still treated as a government as a vocational teacher on a contract basis, and you withdraw your candidature as a selected candidate. You exercise that option. If the government accepts, then you become a contract employee, and then you take the advantage of your regularization.
If I may take a lordship to page number 86. Page number 86. In this case, my lord, two writ petitions, WPC number 64 and WPC number 52, were disposed of by this common judgment, my lord. In this case, my lord, both the petitioners in these two cases, they have already rendered working as CSS and
Please don't do it.
CSS and ad hoc, my lord.
Please
And
don't try to confuse us.
my lord,
We are already confused. You see,
it's written in the judgment, my
we'll
lord.
tell you what blunder you are doing. It can be interpreted to be attempt to mislead the court. That's why please be cautious. Come to page 89.
89.
Yes.
Yes, your lordship.
Second paragraph. Brief facts of the case projected by the petitioners in WBC so and so is that the petition number 1 to 9 were appointed a high school teacher.
Yes, your lordship.
SSA under this is not under Service Shiksha. So these petitioners were appointed as high school teachers and therefore they were in government service.
On direct recruitment thereafter. Their previous.
So
their previous,
that was an ad hoc appointment and the appointment is under the state. So therefore 2013 regularization scheme covers this.
No, my lord. No, my lord. These ad hoc teachers, earlier they were working under the capacity of ad hoc, and then there was an open advertisement quoted by the state government. And subsequently they were recruited into government regular service on direct appointment.
But come to page 91. You were under the government service. After that, you were not upgraded. Paragraph 4 says, filling up of 111 teachers of government school in science and science, advertisement was issued. And then all the petitioners applied for the post advertised through the proper channel and after going through the selection process. So we don't have this advertisement with us. Definitely this advertisement would say that the persons who are the ad hoc employees will be accommodated.
It's an open advertisement.
This is not an open advertisement for everyone.
It's an open advertisement, my lord.
Where is that? Show us, we bring it on record.
Yes, your lordship. Para 4 itself speaks for itself, my lord.
Yes.
For filling up of 111 posts of government high school teachers in science and maths subject, an advertisement was issued by the MPSC on 6/1/2017. Two advertisement numbers are censored. All the petitioners applied for the post of advertised through proportional. And after going through the selection process, they were appointed. So this is an open advertisement, my lord. And besides this, my lord, the secondary petition, my lord, within this judgment, Para 8, Para 8. The first batch of this judgment, this case, they had rendered ad hoc service prior to their regular appointment on direct recruitment. And in this Para 8, my lord, the second batch of the petition, my lord, they had rendered prior service in the capacity of CSS. And they were subsequently recruited through direct advertisement, direct recruitment.
Okay.
And besides this, my lord, under this page number 112, these 55 high school teachers who had earlier rendered their services as a teacher under CSS, they have also been given recruitment on direct basis, direct recruitment, and were granted the same benefits.
Just a moment.
Yes, your lord.
Yes.
My lord, in this WPC number 64,
Page.
the same judgment which I'm referring, page number 96, 97, page number 97.
Yes.
There also may kindly notice that in this case there are two writ petitions, and one batch of the writ petitioners had rendered their past service as an ad hoc, and the other case they had rendered their past service as CSS, and both the writ petitioners were recruited into government service regular appointment by way of direct recruitment by floating an advertisement by the commission. So, like the present petitioner, they were claiming their past services rendered under ad hoc and CSS for the purpose of granting them senior selection grade.
Okay, and where is that notification and the corrigendum? Please come again.
This number 68.
68.
You also may see from page number 70, the type copy will be legible from here. 1B. And after this notification, 19 July 2013, you'll also this corrigendum, page number 72.
Where? 72.
72. Corrigendum, 2nd July 2014. In the original notification, it provided only for ad hoc and deficit service. But by this corrigendum 2014, it provided extended to CSS service. Page number 72. Corrigendum dated 2nd July 2014.
Okay.
In the corrigendum, it refers to Hindi teachers, but those similarly situated CSS employees that earlier approached this court and claiming the same benefits for they being CSS, and which was already allowed by this honorable court and has already been complied with by state respondents.
Yes.
And even without intervention of this honorable court, my lord, the state respondents had extended the same benefits to other similarly situated employees, which is in page number 112.
You have cited three judgments.
Yes,
One is
sir.
33 at page 73. The
Yes,
other
Your
is page 86. What is the third one?
My lord, in this page number 86 judgment, there are two judgments. This is a common judgment of WPC number 64.
Okay.
If your lordship may kindly turn to page number
No,
88.
these are only the two cases, or there is a third one? There are only two cases.
Two cases.
Okay.
In the second cases, there are two petitions.
No, that's okay.
And what I'm referring is page number 112.
Page
112.
112.
This
Yes.
is a notification of the state government.
Okay.
These 55 high school teachers were appointed on regular direct recruitment, and prior to that, they had rendered their past service in the capacity of CSS, and they had extended the same benefits to these 55 high school teachers who are similarly situated with the present petitioner, and without intervention of this honorable court.
Okay. Yes.
Yes, Your Lordship. In reply to his, Your Lordship, if I may take Your Lordship to page, para number 7 of my affidavit in opposition.
Para 7.
Yes. Here, Your Lordship, it is written that the claim which the petitioner
Just a
had
moment.
made.
Yes, para 7.
Yes, in
My
para
lord,
7.
my lord, may I, just one point before my learned friend starts her submission. This notification 2013 and corrigendum 2014 are not for who have been regularized on the same substantive sanction post. For those who have been regularized on the same substantive sanction post, the state government had notified the rules of 2020, the counting of past service rules 2020,
Page?
which is in counter affidavit of the state respondents, page number 31.
31.
31 of the state affidavit. These rules of 2020, irrespective of the inapplicability of the same to the present petitioner, these rules provided for those, it governs those employees who have been regularized on the same substantive sanction post. But the notification 2013 corrigendum which I'm claiming at present is not for the same substantive sanction post.
Please repeat again. Please repeat again.
Yes, Your Lords. These rules of 2020, counting of past service rules 2020, is specifically meant for those who were regularized on the same substantive sanction post as provided in para 2. Para 2. It provides that these rules shall be applicable to all Group A, B, C, and D employees with prior service rendered as work charge, contract, provisional, or any ad hoc officiating employees under the government of Mizoram, including service rendered under CSS or other scheme-borne post, and deficit ad hoc government-aided school, upon their regular appointment to the same substantive sanction post.
Okay.
Yes, Your
Yes.
Lordship. I'm referring to para number 7 of my affidavit. And here it is clearly state that the claim is not applicable as the counting of past service is admissible only for employees who have been regularized by the government in the same substantive post. In the present case, the
But
petitioner was not
we'll show you
regularized.
something which has upset your case. Please come to paragraph 5 at page 4 of your affidavit.
Yes,
Subparagraph, it is also submitted that both the appointments, that is so and so as a vocational teacher, pertain to same individual. It is evident from the period of so and so. The petitioner simultaneously has 2 government posts.
yes.
So that means you admit that he was a government employee.
During his contract employment, he was appointed again. So he applied.
That's a different issue because he got appointment on 7th, resigned on 12th. Because that was not a disqualification. In your advertisement, it's not a disqualification that if somebody makes an application who is already a government service holder,
Yes,
then he would be debarred.
yes, we have stated that.
So therefore, if he is appointed, then this 5 days salary would not matter to anything. It will not be a misconduct. But here you admit that he is a government servant. And therefore, why if he is an admittedly a government servant, he will not be entitled to any other benefit without even going through all the arguments which had been advanced.
Yes, and my only point is that, Your Lordship, in order to claim what he has claimed, he has to be in a substantive post. But now his appointment is in 2 different posts. So he cannot count his past service.
That's your scheme. CSS is covered. Centrally sponsored scheme has been covered by your corrigendum. You have not said anything about the non-application of the corrigendum to the petitioner. Come to paragraph 11. You say that the petitioner is not entitled to counting of a past service as vocational teacher in government high school under the CSS in terms of notification and corrigendum. How?
This is because he was not regularized into government service through the prescribed departmental procedure, but was appointed through direct recruitment conducted by the MPSC, Mizoram. Further, the petitioner entered government service as a government high school teacher, which is neither the same post nor with the same cadre as that of a vocational teacher in government higher secondary schools.
But this has been interpreted by this court, by the judgment he has referred to. It relates to the same advertisement. The judgment which he is referring to refers to the advertisement at page 43. It is the same advertisement by virtue of which the petitioner was appointed. Which paragraph in that earlier judgment referred to that advertisement? There was a reference to the advertisement of 6 January 17 in the earlier judgment you have shown. Which paragraph?
Paragraph number 4, page 91, page 91.
1991. Huh. We'll continue post lunch. He's been able to make out a case.
Will be posted for tomorrow. Because we have filed additional affidavit. It's not in the file now. Will be taken up tomorrow.
Ten.
Yes, Your Lordship. Along with the additional affidavit.
Okay. Item 10. Affidavit in opposition
It's additional affidavit.
of the petitioner, appellant.
Regarding additional substantial question of law.
Okay. Both sides are represented. It is submitted by the learned senior counsel for the appellant that an additional affidavit has been filed in the matter, which is not on record. Accordingly, list the matter tomorrow.
My Lord, in this case, I have instruction to appear on behalf of the respondent number 1. I will submit my power today.
Okay. The learned counsel for the respondent number 1 has entered appearance and submits that he would be filing his vakalatnama in course of the day. Next para. As prayed for, list the matter on. Pick it tomorrow. 11:08. Okay.
Nice.
Yes, Your Lordship, if I may, this matter, the citation which the learned counsel had placed, this is under appeal, Your Lordship, and bearing registration number, writ appeal number 17 of 2025. So now it is pending.
Writ appeal has been filed.
Yes.
Has the operation of this order stayed?
Now, yeah, I don't know exactly the
This
state.
page number 86, judgment, my lord, page number 86. In this judgment, my lord, two petitions were clubbed together and disposed of by this common order.
Yes.
And so far as WPC number 52, 2022 is concerned, it has already been complied with and implemented both in letter and spirit. I have also enclosed the compliance letter, my
No,
lord.
that's part, but has the appellate court in the appeal
And
stated?
amongst the two petitions, my lord, after complying the one case, they have preferred an appeal in the other case, and delay is yet to be condoned. After 553 days, they have preferred an appeal. Delay is yet to be condoned, and as on day, this judgment has a force of law. No stay.
Yes. Yes.
Yes, Your Lordship. And another grounds which I would like to raise is as per my affidavit, para number 12, Your Lordship. I have stated that that is in page number 8 of my affidavit.
Page number 8.
8, yes. Page number 8, para number 12. Here, Your Lordship, I have stated that the notification dated 19/7/2013 and the corrigendum dated 2/7/2014 refers specifically to regularization effected through the prescribed departmental procedure and not to appointments made through direct recruitment by the Mizoram Public Service Commission. Accordingly, the provision for counting the past service rendered as a contract employee under the centrally sponsored scheme or the state government is applicable only in cases of regularization through departmental procedure and not in cases of appointment through direct recruitment by the Mizoram Public Service Commission. So the past service of the applicant is recruited under Mizoram Public Service Commission, Your Lordship. Your Lordship, my grounds is that the petitioner is not in a similar situation to the teacher whose services were counted as recorded, which the learned counsel has cited in his judgment and order, Your Lordship. They were not situated in a similar situation. And as per the notification, there has to be substantive appointment without break. So the petitioner herein, there is a break between their appointment. There is two advertisement. His service is not continuous. And Your Lordship, as per my affidavit, which I have stated in paragraph number 17, here we have clearly stated that the teacher who were permitted to count their past service were all regularized or appointed to the same or similar post. So, Your Lordship, now the present petitioner is not regularized in the same post as well as same appointment.
Yes.
And my another point is that the service rendered by him, by the petitioner under the CSS and the state contract employee, and his subsequent employment under the state government through the direct recruitment pertains to entirely different posts belonging to different cadres with different nature of work. So the claim which the petitioner had made that he is in continuous service cannot be accepted, Your Lordship.
Just a moment. Please repeat again.
Para number 19, Your Lordship. The service rendered by him under the CSS and the state contract employee and his subsequent appointment under the state government through the direct recruitment pertains to entirely different posts belonging to different cadres with different nature of work. So his claim is neither admissible under the existing rules nor comparable to any previous cases under this department, under the department. And also, Your Lordship, as I have stated in para number 17 in my affidavit, the teacher who were permitted to count their past service were all regularized or appointed to the same or similar post. That is from high school teacher under the CSS to high school teacher under the state government, and from middle school teacher under the CSS to middle school teacher under the state government, Your Lordship. Which is completely different with the situation of the petitioner, Your Lordship.
But we find your stand to be oscillating stand. Please come to page 73. '73 is the judgment in WBC 33.
Yes,
correct?
Your Lordship.
Please
Yes.
turn over to page 74. The case of the petitioners is that they were appointed under Operation Blackboard, centrally sponsored scheme, contract under Sarva Shiksha Abhijan. Last 4 lines, huh?
Yes.
The state and fixed pay, and therefore the responsibility given to the application of writ petition submits that he has received oral instructions from the deputy director that the case of the petitioner will be considered in terms of the corrigendum dated 2/7/14. Therefore, this is a case where it was for regularization, correct?
Yes.
So paragraph 8, it says recommended for regularization. Now, please come to this page 86, which is WBC 64 of 2023. Para 2, they were appointed as high school teachers on ad hoc basis. Then, for filling up 111 posts, para 4, this refers to the advertisement annexed to this writ petition, which is the same at page 43. Correct?
Page 4.
Now,
Yes, this is the advertisement. 6/1/2000.
now paragraph 7. Counsel of the petitioner submits that as many as 55 teachers appointed along with the petitioners and so-and-so presiding and RMS being appointed as government teachers by notification dated so-and-so are allowed to count their services under RMSA as qualifying service for so-and-so. And in the middle, the submission is that the London Council submits that the case of the petitioner is squarely covered by the judgment and order of this court and so and so. Now, please come to paragraph 9. Petitioners number 22 to 34. This is you got to 60 advertisements. We don't know about this advertisement. Correct?
Yes, yes.
They were confirmed in service and their appointment as per the 2 advertisements. Therefore, here they project that their cases were same as the previous one. Here you don't raise any objection. And para 11. The London Government Advocate, by referring to the affidavit in opposition, more particularly 6 and 20, submit that it was admitted floated by MPSC. Those who are in government service should apply through proper channel. The petitioners were given no objection certificate to participate. But however, the same cannot be the basis to show the petitioner in government service prior to appointment of so and so. So this is the same contention you are raising now. Correct?
Yes, Your Lordship.
Now, para 12, next page 97. Even though petitioners in WBC 30 were initially appointed under centrally sponsored scheme, they were appointed as state contract after the discontinuation of Operation Blackboard, and subsequently they were regularized through contract regularization scheme. So apart from the contract regularization scheme in this case, the petitioners in the present writ petition and this judgment, they are almost similar except for regularization. Now, next time, how in case of the present petition, they were neither appointed by state contracts or regularization, and there were petitioners and those, but they were directly recruited. So here, the court took into cognizance that they were directly recruited pursuant to that advertisement.
And here in para 14, that is in page 98, Your Lordship, it is written from the second line. For the purpose of counting 8 years of service in the entry grade, here it is written, the services rendered in ad hoc deficit service continued by regularization in government service without any break shall be counted as qualifying service.
So same thing like petitioner, here they are not, they are without break.
Here my submission is that he is on break because he is appointed through two advertisement. Not the similar advertisement. His appointment is 2 times. So counting his past service cannot be admitted.
No, please tell me if A who is in ad hoc service, we have read earlier that he has been given permission to, it's not your case that he has applied in the advertisement without your consent. So if he has applied with the consent, has got the job. It is not your condition that you resign from it and then come. So he gets his appointment here, and after 5 days he takes his, he leaves that contract job. So what is wrong in it? Once you don't draw up a disciplinary proceeding, it is not open for you to say that the action was illegal. If the action was illegal, you would have taken steps long back.
His resignation is accepted by.
And it is not that, it is you who have given them the no objection. He has gone there, taken an appointment, and now comes here and withdraws. So at best is that you can deny him the 5 days of salary once you are aware of it. Is it illegal? It would become illegal if he claims salary and you have paid it to him and he has not refunded.
Yes.
By mistake, if you pay a government servant, instead of 1 rupee, 2 rupee, you can ask for return of that money except if the principles of Rafiq Masih applies. Then this court takes into cognizance this, and in para 16, this court says that rules of 2020 is applicable to all employees with prior service rendered under Rule 2 of the 2020, respective of the date of regularization, whether or before the said rules came into force. And in paragraph 17 says that clarification made through memorandum so and so, clarifying the rule will apply irrespective of the date of regulation of service, cannot be made applicable to the petition particular facts framed under the powers of Article 209.
And Your Lordship,
whereas the office memorandum is executive.
Your Lordship, as per my affidavit in para number 5, it is stated that the petitioner had assumed his charge on 12 to 2018, but
You are reading where?
para number 5 of my affidavit. So he assumed his charge on 12 to 2018, but however he submitted his resignation letter only on 28 to 2018.
Doesn't matter, the government has not done anything in 2018 to now we are into 2026. For 8 years.
I have clarified that point in my rejoinder affidavit.
What have you said?
My stand is that my earlier resignation letter was misplaced, so I was asked to submit again. That is the reason the date looks like the post appointment order.
Which paragraph?
Para 6 of my rejoinder. I have submitted again on bona fide as instructed by the official concern.
And then the learned counsel for the petitioner relies on this page 112. For 55 high school teachers, you have done it.
Ayan, dyan ngayon eh. Counting na rin tayo. Masya nang may lang. Dahil sa ito, 55. Exploitation, this is all. And Your Lordship, the notification dated 24 April 2020, which the applicant has faced. Here, these 55 teachers who were qualified, who was keeping as qualifying service, his name is not there. He is not termed as a qualifying.
Pardon me, please come again.
Out of these 55 candidates,
Annex 1, page 113.
yes, the applicant is not there. The applicant is not, his name is not here in the list.
No, you see, if had his name been here, he would not have come to court. He would have got the benefit.
Exactly, Your Lordship, that is what I'm trying
He's
to
here,
say.
he's trying to say that you have done it for others. Why for him you are denying it?
Yes, Your Lordship, as per my affidavit in para number 5, I have stated that disciplinary action has to be taken against him because of what he have done, because of filing his resignation belatedly, and he is holding 2 posts under the state government.
If that is your concern, that we can always address that.
Yes.
That is that is merely a judgmental error. Is it your case that you have paid him salary for that 5 days? Has he enriched himself illegally?
Yes, we are placing.
That's not your case.
illegally. We
No,
are saying that.
No, you see, let us see a situation which is different from what is there. A person becomes ill today. He is a government servant. He is ill, he cannot do anything. Next day, he files an application that yesterday I could not come and therefore grant me leave. What happens if you grant him leave? Post facto, it can be granted. If you can show that yes, he resigned on 12th, and from 5th to 12th he has claimed his salary and he was paid. That is one. Second is that in every government institution, the salary bills are drawn up by the DDO, drawing a disbursing officer. If I am to get my salary, I don't sign my bill. It is my DDO who is the Registrar General who gives us the salary and he makes a bill. Now what happens if I had availed a leave yesterday and for that inadvertently a bill is made? So if somebody has not attended the classes, you know the procedure more better than us in dealing with service law. And this is not a case where you're drawing up a disciplinary proceeding. And therefore, if you have not drawn up a disciplinary, that cannot go against him. And if this court says that he is covered by that, and others have been given benefit out of the same advertisement, the petitioner cannot be treated differently. In this other, the appeals which have been filed, although there is a delay or whatever, you are the counsel appearing there also?
Yes, Your Lordship.
Then I better adjourn it to some other day. The reason is I take the view which is being addressed by the learned government advocate. I'll tell you the reason why. Please come to the corrigendum. This corrigendum is for, at page 112, is for qualifying service for placement to the senior and selection grade. Correct?
Yes, Your Lordship.
This is not for a new service. This has been,
CSS.
according to my view, this is not what I'll approve of. Because if I pen it down taking a different view, I'll have to refer it to a larger bench.
There's also, if I may say so, there's also a division bench order of this court regarding this issue that saying that these benefits are extendable to CSS employees like the present petitioner.
Whoever been appointed as a new recruitment under the advertisements.
Yes, Your Lordship.
Where is that?
As that is not in the issue in the present case, I do not have that, but it has been referred in this judgment also, in the referred judgment. In the referred judgment under this case, my lord, it is reproduced. Page number 80.
80.
Para 13, fourth, fifth line, my lord. There's several judgments referred in this case.
Page 80, yes.
Para 13, fourth, fifth line.
Get us this, yes. Get us this copy of this one. Give a printout. WA 5 of 13 and 6 of 13. Is it available? Let's find it out. This 13, writ appeal 13 is unlikely to refer to the corrigendum. That is, corrigendum is of 2014.
The judgment, the order date, kindly see the order date. The order date in the writ appeal, kindly see the order date.
Just give it, just give it again.
2007.
The date of the order, 2015. 16/10/2015, passed in WS so and so. 16/10, the order is, the disposal date is 16/10/2015.
Para 13.
Para 13, fifth line.
Order dated 15. But this is writ appeal of 2013. In 2013, the corrigendum was not there.
During pendency of that case, that corrigendum came into being and it was taken into consideration.
It's referred there in the judgment.
Yes, yes,
Okay,
Lord.
just find it out. Now get a printout.
And also this WPC 76 2017 and 132 2016, this post on 8/11 2017, same case, similar situated. As well as those WPC number 76 2017, 132 16. And in the meanwhile, my lord, these 55 high school, middle school teachers, which I have referred in page number 112, they were also appointed along with the present petitioner by common appointment order. And in the present case, my lord, the advertisement which I have been referring again and again, it stipulates that amongst
No,
other that,
this is page 113 you are referring to. Is it?
yes, your lordship,
113 is for placement to senior selection grade. This
Yes,
is
sir.
not for a new appointment.
what I mean to say is that, my lord, these people in page number 112, 113, 55 of them, they were appointed along with the present petitioner.
We are
on
not
the
concerned with
recruitment
that.
By,
The reason is very simple. That's why we say I am against this proposition you are arguing. They may have been appointed with you, but this page 113 is not a case of fresh recruitment.
they were, my lord,
This is a case of placement to senior selection grade.
my
So
lord.
this could not have been read to read the corrigendum to mean government servant appointed under direct recruitment. It could
My
not
lord.
have been.
We were appointed on similar order, along with these 55 of them. Page number 50 is my appointment order. They were also included in this appointment order, these 55 people,
Page 50.
50, Annex 11. Herein I was placed at serial number 53. The present petitioner is placed at serial number 53, which is in page number 51. And those 55 persons referred in page 112 were also in this common order, common appointment order. We were all direct recruitees. There was an advertisement. Advertisement stipulated amongst other that those government servants should apply through proper channel. So I have applied through proper channel. My application is in Annexure 10 of this petition. Thereafter, I was offered the appointment, meaning thereby there was no break in service. Otherwise, Your Lordship, if Your Lordship may permit, we may also wait for the outcome of that appeal.
So you are saying that they were appointed in the advertisement, page 43.
Yes, Your Lordship.
After that, the appointment orders, which is at page 50,
50.
it contains their name also.
Yes, Your Lordship.
And they were given the benefit
They were given without
at page
intervention.
113. Page 113 is the
Yes,
benefit
yes,
given to
yes, Your
them.
Lordship. 55 of them they have given by counting their past CSS services prior to their direct appointment. And if I may, those writ petitioners in WPC number 52, 2022, which was already disposed and complied, were also appointed by this page number 50 appointment order.
Where is that? How can this WPC 33,
Same advertisement,
WPC 52?
WPC 52.
Okay. Just was one name.
Your Lordship may come to page number 51. Page number 51,
Yes.
serial number 98. Serial number 98. HD
Lal
Nunzira.
Zulia.
He is the petitioner number 1 in WPC number 52.
Okay.
That can be appreciated from page number 88. And this shows that the petitioners in WPC number 52, those people in page number 113 and the present petitioners had all rendered their past service
Same
under
appointment order.
CSS, and followed by open advertisement applied through proper channel, and after having been appointed, these people were already given the benefits. And these few people under WPC 52, they have approached this honorable court, and by this common judgment order, it was already allowed, and that has already been complied with by the state respondents. The compliance order is in page number 102 of the present writ petition, my lord.
102.
102. They have now complied. The other case amongst the common judgment order, yet they have reached the other case.
Okay.
The conjoint reading of the notification and the corrigendum was that either ad hoc deficit or CSS past service can be counted after being appointed on regular basis.
Okay. It will print out. It's coming from side. Okay. We don't have a system printer here. We don't have a system printer here. Okay. Is this connected to the computer, to our database? We can see it here in this monitor. No, this monitor. No, in front of me, this monitor. No, you see, you can have a database connected so that the orders we can see here only, or a printer here, because in principal seat in my courtroom we have it here only. I don't have to search anywhere. No, printer may not be here, but there can be a display of the orders here, because my monitor is connected with the court master. So if you open it up there, I can see it here. You ask the IT people to make me. Please come this side. I will explain. Just ask him to come here. Ask your systems person to come here and ask your system person to come here. Please come over. System, this is. No, it's okay. It's okay. Doesn't matter. Doesn't matter if they hear it. No problem. See, the court master has access to a CS system. He can have all the data here. Supposing I want the information about one bail matter or any case, the master should not only open it up, no? And whatever is there in the screen, if there is a screen here also, I can also see it. Just like you have it with the private secretaries, whatever I am dictating, they can see it, I can see it. So in the principal seat in my court, they have done the same system. So if the court master opens up one, just like today we wanted to see a judgment, I don't get the entire printout. I just see the order, and then proceed. Only whenever it is required, then we will have the printout. So, because we have a monitor here. This monitor can be connected so that this live streaming, I don't have to see myself. So there I can see that there is the LDCI system. For example, at times, the filing steps we have to, they said that affidavit has been filed. So in my system, when we look, it shows in the system that affidavit filed. So that's, we'll speak to it and then it can be activated. So that what happens is that we don't have to learn about it. What happens if we want, we can see it here. Because somebody will say that coordinator will just pass this on. So what is the document? Speak to the device. Okay, in the meantime, you take down. Anything more you want to add? Close it? Okay. Please take the names, heard so and so, for the petitioner and the government advocate for the respondents. Next, Baba. Next one. In brief, the case of the petitioner is that he had rendered service as a vocational teacher on contract basis since 8/1/2010 under the centrally sponsored scheme of which Sarva Shiksha. Where is your appointment order?
My lord, his particular appointment is not under Sarva Shiksha.
Under
Sarva Shiksha people
central
were different
scheme of
persons.
Sarva Shiksha
Please
Abhiyan,
number
page
30.
30.
This is my appointment, initial appointment.
Okay. Wide. On contract basis, wide office order dated, I had said that I had rendered vocational teacher on contract basis, wide office order dated 8/1/2010. His contract was extended from time to time. Full stop. Thereafter, pursuant to an advertisement number 21,
Before
of-
that, my lord. Page number 34. Page number 34.
yes,
The service of the petitioner was absorbed under state plan on contract basis.
okay. Okay. Then it will be that thereafter, by a notification dated 5/4/2013, comma, the appropriate government was pleased to order absorption of 48 numbers of vocational lecturers under the, what is HSS?
Higher secondary school,
Under higher secondary schools on contract basis under the state plan. Accordingly, it is projected that the service of the petitioner was absorbed by the government of Mizoram. Full stop. The service of the petitioner as vocational teacher was extended from time to time. Stop. Thereafter, pursuant to advertisement number 21 of 2016-2017, issued by the Secretary, comma, Mizoram Public Service Commission, comma, the petitioner participated in the selection process
through proper channel.
through proper channel and by office order number, this number you please take it from page 50, flag. 50. Dated 9/2/2018. As high school science teacher, you will be mathematics teacher.
No, my lord, science. This advertisement is for science and mathematics. I am on the science stream.
Okay, science teacher. Full stop. Next para. The government of Mizoram, School Education Department issued a notification dated 19/7/2013 by which certain eligibility criteria for pay upgradation of government primary school, middle school and high school teachers in the senior and selection grade was made. Full stop. This was followed by a corrigendum dated 2/7/2014, which provided, give a dash, inverted commas, page 72, I have tick marked, for counting of qualifying service, this part. It's Full stop. Accordingly, comma, the petitioner claims that while other similarly situated persons were given their pay upgradation, comma, taking into account the past services, comma, the petitioner was deprived of the same. And accordingly, by filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has prayed for setting aside the letter dated 12/2/2019 within bracket annexure 15, comma, letter dated 12/4/2022 within bracket annexure 19, with consequential prayer to provide benefit of pay upgradation in terms of notification dated 19/7/2013 and corrigendum dated 2/7/2014. Full stop. Next paragraph. The learned counsel for the petitioner has submitted that by office order dated 9/2/2018, comma, through open competitive examination, comma, the petitioner along with 101 other incumbents were appointed as government high school teacher. Stop. Out of the said appointees, comma, 44 numbers of appointees were no, sorry, 58 numbers of persons were appointed as high school science teacher, including the petitioner, and 44 numbers of persons were appointed as high school mathematics teacher. Full stop. He has submitted that out of the said appointees, "55 numbers of appointees were allowed counting of past services rendered as RMSA teacher for placement to senior / selection grade." And pursuant to judgment and order dated 6/5/2024, passed by this court in WBC 52/2022, comma, 10 further appointees were rendered ad hoc teachers were upgraded to higher grades, comma, IE, comma, senior and selection grade scale. Full stop. So it's further submitted that a batch of civilly situated teachers who are appointed on a contract of the ad hoc basis had approached this court for being granted the benefit of pay upgradation as per the notification dated 19/7/2013, read with originally dated 2/7/2014, projecting that they had also rendered service under the centrally sponsored scheme. And this court, by a judgment and order dated 28/3/2018, passed in WBC 33 of 2018, allowed the repetition with a direction to the respondent authorities to process the case of those petitioners for counting their services rendered under the centrally sponsored scheme for their placement to senior and selection grade pay in terms of the said notification dated 19/7/2013 and corrigendum dated 2/7/2014 within a period of 2 months. This benefit is given by page 83.
Yes, Your Lordship.
So accordingly, it is also projected that by a notification dated 12/6/2018, the benefit of the said notification dated 19/7/2013 while notification dated 12/6/2018, the benefit was given to 47 middle school teachers as qualifying service for placement to senior and selection grade scale Madam, there was some illegality here. You've seen that There were 46 writ petitioners. Appointment was made to 47. Next para, it is submitted that another batch of similarly situated teachers who had rendered contractual services in the past and were appointed as school teachers along with the petitioners by notification dated 9/2/2018 had approached this court for similar relief by projecting that their cases were covered by the judgment and order dated 8/11/2017 passed by this court in WPC number 33 of 2018. Stop. Though the learned government advocate had taken a stand that the petitioners in WBC 64 of 2023 and WBC 52 of 2022 were not similarly situated as they were directly recruited. But this court by judgment and order dated 6/5/2024 passed in WBC 64 of 2023 and WBC 52 of 2022 held that those petitioners were entitled to be considered for counting their past services rendered prior to the regular appointment in terms of notifications dated 19/7/2013 and 2/7/2014. And accordingly, those two petitions were allowed, directing the respondent authorities to carry out the exercise of counting their past services rendered under the centrally sponsored scheme / ad hoc appointment for their placement to senior and selection grade within a period of 8 weeks from the date of receipt of certified copy of the order. Full stop. Accordingly, it is submitted that the services of the petitioners in WPC 52 of 2022 were upgraded to higher grades of senior and selection grade scale by notification dated 4/12/2024. And what happened to this 64, WPC 64?
In this case, my lord, they have belatedly preferred an appeal. After making a decision to comply, they have decided to prefer an appeal, most probably for delaying the matter.
Okay, in 64, appeal has been filed.
Appeal has been filed, but delay is.
No, it's
there is
okay,
about
that's apart.
500 plus days delay.
No, that's okay, but this appeal has been filed in 64.
Yes, Your Lordship.
64. Full stop. The learned counsel for the petitioner submitted that insofar as WBC 64 of 2023 is concerned, the state respondents, without complying with the directions contained in the judgment and order dated 6/5/2024, passed in WBC 64 of 2023 and WBC 52 of 2022, had filed a intra-court appeal with substantive delay, which is pending for consideration by this court. Next paragraph. The learned government advocate, by referring to the stand taken in the affidavit in opposition, has submitted that the petitioner was appointed as a teacher pursuant to the advertisement dated 9/2/2018. No, sorry, it is advertisement dated 6/1/2017, wide office order dated 9/2/2018, and he assumed charge on 12/2018. Stop, however, he had submitted his resignation from the post of vocational teacher on contract basis only on 28/2/2018. So accordingly, it is submitted that the conduct of the petitioner constitutes a clear violation of Rule 15 of the Central Civil Services within bracket conduct bracket close rules, 1964. It is further submitted that the case of the petitioner is not covered by WBC 33 of 2018 or WBC 64 of 2023 and WBC 52 of 2022, because the service of the petitioner was not regularized in the post which he had, in which he was working as a centrally sponsored under the centrally sponsored scheme, and he was not under the state government contract, and therefore, as the petitioner was directly recruited and appointed by notification dated 9/2/2018, the petitioner was not entitled to the counting of his past service under the notification dated 19/7/2013 and corrigendum dated
2014.
2/7/2014. Stop. It is further submitted that the government had rejected the proposal for counting the past service in respect of the petitioner in accordance with the provisions of the Mizoram Employees within bracket counting of past service bracket close rules 2020. As the eligibility for counting past service is confined to employees appointed to the same substantive post. So accordingly, it is submitted that the past service rendered by the petitioner as a vocational teacher is neither the same post nor within the same cadre as that of a vocational teacher in the government higher secondary schools. And accordingly, it is further submitted that the claim of the petitioner is not admissible under the existing rules. So it is further submitted that the petitioner is not entitled to the benefit of any pay upgradation as the service rendered by him as a under the centrally sponsored scheme does not make him a government servant. Next paragraph. Next paragraph. Consider the submissions made by both sides at the bar. Next paragraph. It is not in dispute that by virtue of the notification dated 19/7/2013, the petitioner was not entitled to a pay upgradation. However, as for the case projected by the petitioner, he had become entitled to the pay upgradation pursuant to corrigendum dated 2/7/2014. Full stop. The said notification, the said corrigendum dated 2/7/2014 is extracted below. This is page 72. And in this record, this is the order of 16/10/2015. This has it, so you can copy it from there. Next paragraph. The petitioner has been able to demonstrate from the documents appended to this writ petition that pursuant to the judgment on order dated 28/3/2018, passed in WBC 33 of 2018, those 46 petitioners, along with one other person, were allowed by the state of counting of contract service under the centrally sponsored scheme for placement to senior selection grade. By notification dated 12/6/2018, bearing memo number C full stop 14011/8/2018-EDN, issued by the Commissioner and Secretary to the Government of Mizoram School Education Department. First of all, the petitioners have also been able to demonstrate that the writ petitioners in WBC 52 of 2022, pursuant to judgment and order dated 6/5/2024, were also given the benefit of pay upgradation by notification dated 4/12/2024, within bracket annexure 25 to the writ petition. Full stop. The petitioners have also been able to demonstrate that those petitioners in WBC that as per has been able to demonstrate that as per the facts of the case reiterated in paragraph 2, 3, and 4 of the common judgment and order dated 6/5/2024, passed in WBC 64 of 2023 and WBC 52 of 2022, that the petitioners in WBC 52 of 2022 were appointed as ad hoc teachers and they were also the appointees pursuant to the advertisement dated 6/1/2017, and this court, considering the stand of the state held those petitions in WBC, held those petitions, both the rate petitions, to be entitled to pay upgradation. Next paragraph. Therefore, in this case, the petitioners have been able to demonstrate that the petitioners are similarly situated as the writ petitioners in WBC 52 of 2022, as they were also appointed as vocational teachers on contract basis, and they had also been granted regular appointment pursuant to the office order dated 9/2/2018, whereby the petitioners in WBC 52 of 2022 were also appointed. Next. The learned government advocate had referred to the provisions of the Mizoram government employees within bracket counting of past service bracket close rules, 2020. Full stop. The said rules is applicable for those employees whose service were regularized in the same substantive posts, which is not the case of the petitioner.
My lord. Besides that, my lord, these rules of 2020 came into force on 29/5/2020. I was regularized on 9/2/2018. In this circumstance also, this is not applicable to me. Under any circumstances, these rules is not applicable to me.
In this regard, the learned counsel for the petitioner has submitted that though the 2020 rules came after the service of the petitioner was made by way of direct recruitment, and that the petitioners are similarly situated to those petitioners in WBC 52 of 2022. Next paragraph. Accordingly, as the petitioners have been able to demonstrate that the petitioners in WBC 52 of 2022 were also appointed by office order number so and so, page 50, dated 50, dated 9/2/2018, and that the petitioners in the instant writ petition as well as in WBC 52 of 2022 were both appointed on contract basis under the centrally sponsored scheme, the petitioner cannot be treated differently than the petitioners in WBC 52 of 2022 who had been given the benefit of higher grade of senior and selection grade scale by notification dated 4/12/2024 issued by the Special Secretary to the Government of Mizoram, School Education Department. Next paragraph. Accordingly, the petitioners are found to the reliefs at paid for. Next paragraph. Accordingly, this relief petition stands allowed by directing that the petitioners are entitled for counting of their past services rendered prior to their regular appointment, wide office order dated 9/2/2018 in terms of the notification dated 19/7/2013 and corrigendum dated 2/7/2014 thus, the among this respondent numbers 2 and 3, who is the competent authority to do that?
Respondent number 2 is the concerned department secretary.
It will be 2 and 4 then. Sorry, 2 and 5. Finance will come later on.
Finance is 4.
No, we are asking that which will be the competent authority to do so. School Education Department, respondent number 2.
Yes, Your Lordship.
And
the
director 5. Accordingly, the Secretary to the Government of Assam, School
Mizoram.
Education. Government of Mizoram, School Education Department, within bracket respondent number 2, and the Director of School Education, Department. It will be the Director, School Education Department, Government of Mizoram, within bracket respondent number 5. Are directed to process the case of the petitioner for counting his service rendered as a contractual teacher under the
CSS.
Sarva Shiksha Abhijan. Correct?
Sorry, my lord.
Sarva Shiksha Abhijan.
No, my lord, CSS, centrally sponsored scheme. Centrally sponsored.
Which scheme?
Under that scheme, my lord, he was appointed as vocational teacher.
Which scheme? CSS is only the
The
wholesome name.
the fund is from CSS, my lord. It's funded by CSS, his appointment.
Is it RMSA or it is the Sarva Shiksha?
Vocational teacher, as a vocational teacher under CSS.
By which authority? Your appointment? Where is your appointment order?
Page number 30, page number 30.
30.
Page number 24 is the advertisement, initial advertisement.
24.
24. Post of vocational teacher, CSS on contract basis.
Okay, just say what is it, as vocational teacher under the centrally sponsored scheme on contract basis.
Yes.
For the placement under upgraded pay for the pay gradation. For the pay gradation. And placement to the senior and selection grade in terms of notification dated 19/7/2013, read with corrigendum dated 2/7/2014. Next para, it's needless to say that on the recommendations being made by the respondent numbers 2 and 5, comma, what are the concerned authorities? Shall take all such steps as may be necessary to give effect to this order. Next para. The entire exercise as directed by this order shall be carried out within a period, outer period of 3 within words 3 bracket close 3 months from the date of receipt of a certified copy of the order. Requisitions shall be allowed to the extent as indicated above. Next part, there shall be no addressed cost.
Highly obliged.
Obliged.
This, I am placing it here. You can copy it from here. That notification of 2nd July 2014.
Item 11.
Yes, this is item 11.
Ten has already been fixed for tomorrow, my lord. Item 10 has already been fixed for tomorrow.
No, we are not calling item 10. This is item 11. Which one? 10 we have already. You are not calling number 10. This is item 11. None appears on call for the petitioner. Next part, the petitioner has remained unrepresented when the don't say that for ends of justice. The next question. Next paragraph. As this revision has been filed by the Narcotics Control Bureau, for ensuring justice, the matter stands adjourned today. Next paragraph. Where is the filing page? Where is the filing slip? Where is the filing slip? At the top you must have a filing slip. Where is that? Where will you get the details of the last? Okay, this one. Therefore, the registry shall send a downloaded copy of this order, the downloaded copy of this order to the deponent of this revision petition in his WhatsApp number provided in the affidavit of the deponent, Sri S.I. Prakash Ranjan. Next para. The next para, if the default continues on the next date of listing, adverse orders will follow. Next para, the list on so and so, give a date after a week. Next para. Let this order be brought to the notice of the AOG of the criminal revision section. It's criminal revision section. What is this section called? This criminal revision goes to which section? Judicial section. Okay. This is only one judicial section dealing with this. Okay.
Item number 12.
Please, Your Lordship. My Lord, as per the last court order 18.6, we have served notice upon respondent 1 and 2. And however, it appears that the address is insufficient, my Lord. So if I may be allowed to serve by way of the stream, my Lord.
You know what is the effect of your submission? Are you aware of the effect of your submission? You have CPC with you.
No, my Lord.
Just give a copy of CPC. Yes. See Order 6, Rule 14, 5. Please read what does it say. Order 14, Rule 5. Or Order 6, Rule 14, 5.
Lord, order 6, rule.
Order 6, Rule 14, 5.
uh, where the registered address of a party is discovered by the court to be incomplete, false, or fictitious, the court may either on its own motion or on the application of any party order in the case where such registered address was furnished by a plaintiff, stay of the suit, or in the case where such registered address was furnished by a defendant, his defense be struck out and be placed in the same position.
So you stand in this, you are the plaintiff
Yes,
and the
my lord.
appellant here.
Yes, my lord.
You are yourself saying that the address is incomplete, so we have to stay the,
No, my lord, we have aware of the correct address now, my lord. The respondent number 2,
you can't do it because that was the address in the plaint. This is the same address in the appeal. If the address was incomplete and incomplete, then we have no way out but to stay this appeal.
my lord, we have aware that the respondent number 2 work as the MRB branch manager in Fungkon, my lord. The respondent number 2 work as the branch manager.
You have to bring it on record. You just can't serve notice anywhere. If the address is A, you cannot go and serve notice to the concerned respondent at the address B. It's impermissible.
My lord, if I may be given time to file for the application, my lord.
Bring it on record. You can't serve notice anywhere. On the prayer made by learned counsel for the appellants, the matter stands adjourned to enable the appellants to file an interrogatory application to bring the correct postal address of the respondents on record. Full stop. Accordingly, the matter stands adjourned today. List on
2 weeks, my lord.
just after a week as before.
Supplementary list, item number 20.
My lord, here I'm for the petitioners. But as your lordship will see in the last court's order, my lord, the appeal is still pending before the Honorable Supreme Court, my lord. The appeal preferred by the NHIDCL. I have the copy of the last order, my lord.
Stay means the stay of the order of this court.
But against which violation has been alleged in the contempt petition.
That has been stayed by the Supreme
That
Court.
is been stated.
Then we have to adjourn it.
My lord.
Adjourned.
Next paragraph. Heard, Mr.
Seatlan Thianglima.
Please give your names. I may make a mistake.
My lord.
So and counsel for the petitioner, as well as Mr. P.J. Saikal, and his senior counsel, assisted by Mr. Just write it down. And counsel for the respondents. Next paragraph. Referring to the previous order, dated 27/4/2026. And 1/6/2026, comment has been submitted that while the order against which the violation is alleged, the operation thereof has been stayed by the Supreme Court of India. Next paragraph. It has been submitted at the bar that the matter is still pending for adjudication. Result accordingly cover the matters. This contempt petition stands adjourned today. We'll list it after 6 weeks.
Sometime in October, my lord.
That much we can't give. It's such a long date we can't give.
Lordship, in that case, September.
Give a date after 6 weeks because September last it will go somewhere.
29 September.
Obliged.
Then we'll prepare again. No order is required to be passed in this IA.
I was for, my lord, to stay of the further proceeding in the contempt petition. In fact, the order to be passed in that I only.
We pass a common order in both the cases.
It's common order.
Daily list, 4 orders, item number 13.
My lord, each matter may be listed as for admission hearing in the next week, my lord. TCR is received. Grand court records is received now. The matter may be listed for admission hearing in the next week.
This heirship certificate is under which act?
Heirship certificate is issued under the Widow Marriage, Divorce and Inheritance of Property Act 2014, my lord.
Okay, so these orders are passed by the civil court.
Yes, ma'am.
Okay. The records are received.
Yes.
You want us to take up the hearing today?
It can be taken up next week also, my lord. So. Or
If
tomorrow, my
possible,
lord.
my lord, tomorrow, my lord. As supplementary release for admission here.
It's a simple matter, my lord.
No, tomorrow may not be. Fix it next week. Both sides are represented. Where is the impugn order? Which page?
Roman number 1. Roman number 1, right next to index, my lord.
Roman number 1.
Yes.
Okay. It is day after tomorrow. Both sides are represented. It's submitted that the records of the learned trial court is received. Taxpayer has prayed for by both sides. Raise the matter for further consideration on Give day after tomorrow.
Obliged, my lord.
It's only division bench. So after that, Thursday. Okay, it will not be day after tomorrow. These are division bench.
My lord.
Yes. Okay. Next day. It will be
13th
next-
August.
Thursday, my, yes.
Item number 14 and 15.
My lord, in this matter, I'm appearing for the sole respondent, and my objection to the condonation of delay is being prepared. So I seek accommodation for further 2 weeks, my lord.
How much delay is there?
It's 193 days delay, my lord. I would like to file my objection, my lord. It's a appeal against acquittal, my lord. The delay application is IA criminal 14, and the other IA 13 is for leave to file an appeal.
But you have already taken so much of adjournments.
This is the second time after submitting my power, my lord.
1, 2. 2 has already been taken. Today is the third.
Yes, ma'am. If 2 weeks time is granted, then I think I can positively file by then, my lord.
Okay, both sides are represented. As prayed for by the counsel for the respondent, one last opportunity of 2 weeks is granted to the respondent to file the affidavit in opposition in the interrogatory application, failing which the matter would be taken up for consideration on the basis of materials available on record.
Obliged.
I'm obliged.
Item number 16.
My lord, in the last court date, we have sought leave to file an additional affidavit, and the same was filed on Friday. But since the time we filed the additional affidavit, the cost list for today was or had been prepared already, so it could not be reflected in today's cost list. So if the matter may kindly be taken up on Thursday.
Just a moment. You are for the state?
Yes, Your Lordship.
You have not filed before this court any the past criminal antecedents of the petitioner? Why?
Yes, I did not
Why?
file
Why?
written objection.
Why you do not file? We will direct the respondent to provide us instructions with the past criminal antecedents of the petitioner. How much time you require?
2 weeks, Your Lordship.
No, that is too much. He is a bail application. We can't adjourn it for 2 weeks. 2-3 days we can understand.
Okay, if the matter may be listed on Friday, then.
Okay, we are listing this matter on Monday.
Okay,
You file the criminal antecedents
yes.
because it appears that the petitioner has multiple cases of NDPS against him.
Yes.
Both sides are represented. The learned counsel for the petitioner has submitted that an additional affidavit has been filed, which is not on record. Next para. From the contents of the bail application, it appears that there are several cases against the petitioner relating to habitual dealing in the narcotic drugs and psychotropic substances. Accordingly, the court is inclined to direct the officer in charge, Special Narcotics Police Station, CID crime, within bracket, respondent number 2, to produce instructions to produce the past criminal antecedents of the petitioner through the learned APP in form of instructions. Next para. The learned APP shall, you are the special PP
Yes.
or APP?
No, additional public prosecutor.
Additional, okay. The learned APP is directed to send a downloaded copy of this order to the respondent number 2 to bring the order to this notice. Next para. In the meantime, the additional affidavit filed by the petitioner shall be brought on record. Next para, list on 17/8/2026.
Obliged.
Item number 17.
Yes.
My lord, I am the applicant in IA3 of 2026, my lord. But however, I'm the respondent in the main appeal. And my lord, I have filed the dusty affidavit on 16/7/2026, my lord. I was allowed for newspaper publication upon the respondent number 3 in the IA.
You are the respondent number 2.
I'm the respondent number 3 in the main appeal, madam. No, my lord, I'm sorry, number 4 in the main appeal. Respondent number 4 in the main appeal.
Respondent number 4 is the district registrar.
No, Bijoy Gurung.
Bijoy Giving respondent number 2.
No, in the main appeal. In the main appeal, I'm the respondent.
This
number
application is by whom?
4. This application is by me. By me.
Me means who?
The respondent number 4 in the RFA, in the connecting RFA.
Respondent number 4 in the RFA.
Yes, in the connecting RFA. I'm the respondent number 4 in the connecting RFA, and I filed this instant IA for striking me.
Respondent number 4 is Bijay Gurung.
Yes,
Bijay Gurung is defendant number 2.
respondent number 4, my lord, in the main appeal.
Please understand.
Yes, Lordship.
In the
Bijay Gurung is respondent number 2.
Yes,
The defendant number 2. Against defendant number 2, there is a decree. And you want your name to be deleted.
yes, my lord, because in
You
the
are rejecting it.
I was no longer named necessary in the decree, my lord, because
Yes, you are there in the decree. That's why there was a confusion. There is definitely a decree.
decree are against, my lord. Defendant number 1, 3 and 4, 1 and 3, my lord. Everything about me is silent now in the decree. Because I have completed my
The
life.
sale deed executed by defendant number 3 was against 3. There is no against 2 there is no decree.
Yes.
Okay. It is plaintiff number 2, not defendant number 2. Okay. Yes.
Lordship, for this IA hearing, if possible, the matter can be taken up on Thursday for proper hearing, Lordship. The leading counsel today has some personal difficulties, Lordship.
Both sides are represented. The learned counsel for the applicant has submitted that an application under order 1 within bracket rule 10, order 1, comma, rule 10 within bracket 2 has been filed for deleting the name of the defendant number 2, comma, who is the respondent number 4 in the connected appeal, on the ground that neither there is a prayer made against the applicant in the plaint, nor any decree has been passed by the learned trial court. Next para. On the prayer made by learned counsel for the respondent number 1,
4, Lordship.
respondent number 4. But why 4 will take an adjournment? Who is number 4?
In the IA, I'm the respondent number 4. The appellant is highlighted as respondent number 4.
Respondent number 4 is Bijay Gurung.
Respondent in the IA, I'm the appellant is respondent number 4, and I'm the appellant in the main appeal.
You're the appellant.
Yes, Lordship.
Ah. Who is appearing for the respondent numbers 1 and 2?
Lord, I'm appearing for respondent number 1 and 2 in the IA. And as well as.
You were the plaintiff.
Yes, my lord.
Any objection to the deletion of names?
As no, my lord.
The prayer made by the learned counsel for respondent number 3 in the connected appeal, letter stands adjourned today. List again on, make it Thursday. Okay.
Obliged, my lord.
Item 18.
This is a conviction under the POCSO Act, and I have received a copy of the paper book, my lord.
Who appears for the respondent, complainant,
Yes,
or the
Your Lordship,
victim?
Notice has been sent to the respondent number 2, who is the complainant. However, Your Lordship, this morning I received a verbal instruction from the concerned police station, and it is seen that the complainant number 2 cannot be found, nowhere to be found in his address.
It's
So
not
notice
found.
cannot be completed, yes.
Let them submit a report
Yes,
because,
the report is still awaited. They are sending it, but
okay. The learned counsel for the appellant is present and submits that the copy of paper book is received by him. Next para, Ms. So-and-so, the learned APP, has submitted that today morning she has received verbal instructions from the concerned police station that the victim could not be found.
It's the informant, my lord. The informant was the mother of the victim.
Okay, the informant could not be found. Full stop. Accordingly, the learned AVP has submitted, has prayed for some time to bring on record the report of the concerned police station. Next para. The matter stands adjourned today. List on. Yes, by which time?
they have to send from Tanzol, that is different place from
No,
here.
this can come by email to you, produced. We don't need a physical copy now.
By next week.
Hmm?
By next week, Your Lordship. Any day next week.
Next week? Okay. Give a date after 10 days. You just say file a report of the police station which can be done by way of email, and a printout therefore thereof be produced before the court. Next para, as paid for list on, give it 10 days time.
21st of August.
We are permitting you by email and you produce the printout here.
Obliged.
Item 19.
Your Lordship, this is bail application under Section 480 of BNSS. Then, my Lord, the applicant was arrested on 17/5/2026 in connection with the allegation of possession of 25 grams of suspected heroin. Then, my Lord, there are 3 accused in the instant case, and the instant applicant is the only accused who is remaining in the judicial custody. The other 2 accused has been released on bail.
Where is the bail order?
Yeah, my Lord, bail order is in page number 20.
28.
Then, my Lord, annexure number 6, page number 20 is one of the co-accused. Bail
20, your bail application. Your bail application is 27 pages only. Where is the bail order?
Bail order is in annexure 6, my Lord, page number 20. 20.
20, okay.
After filing this bail application, the other co-accused has been released on bail, and we did not annex the bail application.
Is the NDPS Act? No, sir, we have it. You were apprehended with 24 grams.
25 grams.
25 grams.
It's an intermediate quantity.
Whereas per schedule, it's an intermediate quantity. Where will I find it? Intermediate quantity. Quantity.
Your Lordship,
Entry number?
56. 56.
66.
56.
56. Okay. Heroin. Intermediate. Yes, what do you say?
Yes, Your Lordship, I have gone through the petition that is submitted by my learned friend. Nowhere in the petition it is stated that they are not guilty of the office charge against them. Even though the embargo of Section 37 of NT-NPS is not attracted, Your Lordship, their only contention is the sickness of the relatives. And the other grounds that they have mentioned is Section 47 and Section 48 of the BNSS. However, I have seen the reports, Your Lordship, the TCR is before your honorable court. TCR case record.
Records.
Case record. And Your Lordship, and third is that they claim for parity with the accused, the co-accused. Now, the co-accused was enlarged on bail by this honorable court due to the fact that he was seized with, from his possession, 4 grams of heroin was seized. 4 grams. That is a small quantity. A small quantity is bailable, Your Lordship. Now, they cannot claim parity because Your Lordship have seen from the item number 56 of the schedule that it is intermediate quantity. So, Your Lordship, they cannot, first of all, they cannot claim parity with the co-accused so as to enlarge on bail.
No, the other co-accused got 56 grams.
Yes, 56.
He got bail.
Yes, he got bail. But every case, it has to be on its own merits bail. Just because a co-accused is enlarged on bail does not entitle the case to be the present applicant to be enlarged on bail. And Your Lordship, the second ground that they have cited is Section 47 and Section 58. Now, if I may take Your Lordship kind attention to the page number 37 of the TCR. This is the grounds of arrest. However, it's in vernacular language. However, its grounds of arrest was, I just want to show that grounds of arrest was intimated to the accused. Duly intimated. Now, with regards to the Section 48 of the BNSS, Your Lordship, arrest intimation was given to the wife of the accused. Page 45. Wife of the accused, so and so, and half phone number also is there. In writing, Your Lordship, copy received, duly received. Now, their third ground is the health issues of the relatives. Health issues, even though I'm not a medical expert, and Your Lordship, it's hypertension treatment.
Which page?
Page number 4 of the petition. Starting from page number 3.
Page?
Page number 3 of the petition, Your Lordship, application. Paragraph number 5.
Yes.
4 is just, he's the sole bread earner of the family, etc. And 5 is that, his wife is having some serious spinal ailment causing severe lower back pain, etc., accompanied by a medical certificate. And the applicant's father in paragraph number 6 is hospitalized due to hypertension and treatment, which led to hypertension, etc. Now, I'm not a medical expert, Your Lordship, but then this is not, in my humble opinion, a death threat disease or medical condition. And Your Lordship, with regards to the sole bread earner of the family, now he's earning his income by way of doing illegal activities, selling illegal drugs, which cause menace to the society, Your Lordship. So letting him free, Your Lordship, at this stage, first of all, there is a chance of hampering an evidence. And in page number 15, Your Lordship, the charge sheet was duly submitted before the Land Trial Board. Page number 15. The charge sheet, in the charge sheet, it would go on to show that he was the first one, when they received the information, he was the first person that they have, according to he was the one who was selling the illicit items, illicit drugs. And it was from his own statement that the other co-accused were arrested. So he cannot claim parity with the co-accused. That's why I'm saying that every case has to be dealt with in a separate sense, on merits, Your Lordship. Referring to page number 15, the charge sheet, Your Lordship. With Your Lordship permission, may I read just two paragraphs of the charge sheet?
Yes.
Yes. The brief history of the case is that on dated so-and-so around 3 p.m., Inspector Jason so-and-so, a reliable information from his source that a person named Lalong Kima, that is the present applicant, was illegally possessing and selling heroin at Bungkon area. After recording the information, the officer along with his team proceeded to Bungkon and located the suspect and his residence. During interrogation, the suspect disclosed that he has concealed heroin at his residence located in Bongkon, so-and-so. According to the team, proceeded to the said residence. On arrival, the officer said, secured two witnesses from the locality and their presence, and thorough search was conducted. During the search, the accused voluntarily produced suspected heroin kept in two showcases, 14 Tic Tac candies containers and Neosporin container. The duty officer sees so-and-so, so-and-so. The duty team waits so-and-so. And so on further interrogation, he have disclosed that the other co-accused were also in possession of the illicit drugs. So that is why, Your Lordship, I'm saying that the petitioner cannot claim parity with the co-accused. And Your Lordship, my other ground is that they were arrested. He was arrested on 17/5/2026. And today, to be precise, is the 85 days he is in jail. It's very early, Your Lordship.
If it is intermediate, it will be 90 days.
Yes.
But charge sheet has been submitted.
Receipt has been duly submitted. And Your Lordship, considering the fact that the drugs have posed menace to the society at large, Your Lordship, at this stage, what I'm praying is that this honorable court may not allow this application, because admittedly, he voluntarily produced the seized articles to the police himself. And now going through the petition itself does not show that he is not innocent of the offense charged against him at all, Your Lordship. So clearly, the prosecution have a case against him. Statement of the accused also is there, but then since it's in vernacular language, I will not refer to that. I did not have the time to translate it, Your Lordship.
Dear my lord,
Yes.
his other co-accused has been released on bail after filing this bail application. The bail order is in page number 97 of the TCR. Bail order is 97 of TCR, page number. And also, my lord, this article is only 25 grams, and the rigor of section 37 does not attract in this case. And
Not 25. You sold 4 grams to one, 27 grams to another.
Yes, 27 grams for another co-accused. He has been released on bail. And the investigation is already
And
completed.
one had 56 grams.
Brother. From my possession, 25 grams of heroin.
125, another
From another co-accused, 27 grams. And from
one is 56 grams.
all
27, 4 and 56.
the total seized heroin is 56 grams, and only 25 grams was seized from my possession. And I'm the only accused who has been detained in judicial custody.
Today will be 85 days.
Yes, Your
You're
Lordship.
releasing him on bail.
Your Lordship,
Because the regards of section 37 does not apply.
Mm.
Heard so learned counsel for the petitioner and Ms. So learned. You are the special PP or AP?
Additional
Additional
prosecutor.
PP for the state. Taxpayer. The petitioner, by filing this application under Section 483 of the BNSS, has prayed for bail in connection with excise case number N-141/26 under section 21 within bracket small b, comma 21 within bracket small a, and 20 within bracket small b within bracket small Roman 2, and then capital A of the NDPS Act. Next paragraph. On 17/5/2026, on the basis of information received, the a search operation was carried out in the house of the petitioner, and the authorities found the petitioner with in possession of 25 grams of suspected heroin. Full stop. Upon his arrest, he had disclosed regarding sale of drugs to 3 other co-accused, in whose possession heroin weighing 27 grams, 4 grams and 56 grams respectively were seized, along with seizure of further quantity of ganja, 87 grams of ganja. Full stop. Next, the learned counsel for the petitioner has submitted that 2 co-accused have already been granted bail. Next para, the learned APP has opposed the prayer for bail and has referred to the TCR and has specifically referred to the complaint under section 210 within bracket 1 within bracket small a of the BNSS, disclosing that, which discloses that in the discloses regarding the recovery of 25 grams of heroin from the possession of the petitioner. Full stop. The learned APP has also opposed the prayer for bail on account of the vending of the drugs and psychotropic substances by the petitioner to 2 other co-accused. So accordingly, it is submitted that the petitioner is a risk to the society as is habitually dealing in narcotic drugs and psychotropic substances. Full stop. Next part, it is further submitted that the petitioner is differently placed than the other co-accused granted bail on account of the fact that he is the actual vendor and that there is no material before this court that the petitioner would not be habitually dealing with the drugs in future. Full stop. It is also submitted that the petitioner has raised a plea of his wife being suffering from low back pain, which has required her to undergo spinal surgery, and that his father is suffering from hypertension. And it is submitted that the medical ground of the family members is not a good ground for releasing the petitioner for bail, as hypertension is a disease which is widespread and is not critical in nature. Next one. The objection made by the learned APP has merit, as the petitioner, as per the investigation carried out so far, is dealer in narcotic drugs and psychotropic substances, as he is vending narcotic drugs to others in this society. Stop. Next paragraph. Bail sought for on ground of the disease of hypertension suffered by his father was also without any merit. Next para. However, having noted that the petitioner is accused of being in possession of an intermediate quantity of heroin, and he has been taken into custody on 17/5/2026 and has remained incarcerated for 85 days today. Considering the length of detention, the court is inclined to order that the petitioner be released on bail. One is furnishing a bail bond of rupees 25,000 with two surety of like amount to the satisfaction of the learned
Special judge in the NPS.
sessions.
Special judge in the
The
NPS Act.
special judge, ISOL.
In the NPS Act, I saw.
Special judge within bracket NDPS Act, bracket was ISOL. Full stop. The bail is granted on the following conditions. Number one, that the petitioner shall appear before the IO, before the, which police station it is? Before the officer in charge, anti-narcotics squad, excise and narcotics, at ISOL, every 15 days from the date of his release without fail. And the said authority shall record the presence of the petitioner. Full stop. It is made clear that if the petitioner fails in appearance before the said authority till his appearance is exempted by the learned special judge within bracket NDPS, bracket close, ISOL. Comma, it would be open to the officer in charge of anti-narcotics squad, comma, excise and narcotics to move the learned special judge, comma, within bracket NDPS, bracket close, ISOL, cancellation of bail. Next para. During the period of bail, comma, the petitioner shall not deal with or sell or possess any narcotic drugs or psychotropic substances in any form whatsoever. And in the event this condition is violated, comma, it would be open to the officer in charge of the anti-narcotics squad, comma, excise and narcotics to. No, just don't say this every time. At the end, you will say, huh? At the end, you say that if these are violated, then officer in charge of anti-narcotics squad, excise and narcotics shall be entitled to move the not a special judge within bracket NDPS, bracket close, as well to for cancellation of bail. Make it this one paragraph only, huh? Next, petitioner shall appear before the learned trial court on each and every date fixed for appearance. And only when the non-appearance becomes is due to any special reasons, comma, the petitioner shall ensure that he is duly represented by his learned counsel and he will have to give an undertaking before the court that he would have no objection if the trial is proceeded with and or witnesses are examined in his absence. First of however, comma, on those dates, the petitioner shall ensure that he is duly represented by his learned counsel. First of, in the event of default on part of the petitioner to adhere to this condition, comma, it will be open to the learned special judge within bracket NDPS, bracket close, to cancel the bail granted by this court and to issue process to take the petitioner into custody for the rest of the trial. Next, petition stands allowed and disposed of in the extent as indicated above. I put on those conditions. Each and every 15 days he'll appear before the officer in charge, bail of 25,000 with 2 surety. He'll attend the court on each date.
Duly obliged, Your Lordship.
Much obliged.
Oh, you have the, take.